Question is that the bill be now read a second time. Mr. Patrick Tay.
Mr. Speaker, I rise in support of this bill. The Work Injury Compensation Framework is a no-fault system with the aim of providing workers injured in work-related accidents with low costs and expeditious means to claim work injury compensation. The bill seeks to improve the framework to better enable the meeting of its objectives. Briefly, the amendments to the bill are commendable in the following areas. First, there is now a mandatory requirement by MOM to report all instances of MC or light duties due to work injuries. This is beneficial in the sense that there is a less incentive for employers to influence doctors to prescribe fewer days of MC to the injured workers, to circumvent the original reporting requirement of only needing to report injuries which result in death or at least MCs of 4 days. Second, MOM will now accredit a standard work injury compensation policy with a core set of insurance terms and conditions, which reduces disputes from policies with complex policy exclusions. This will ensure that both employers and employees' interests are better protected. For employees, there is more certainty in receiving compensation, especially if employers face financial difficulty. As for the employers, they would know with greater certainty that they would be reimbursed under the insurance policies. Third, under the amendments, there will be an increase in the compensation amount and medical limits in view of rising wages and healthcare costs. This is a recognition on the government's end of the financial implications that workplace injuries have on people, such as loss of income and hefty medical expenses. Fourth, insurers will now be required to share policy and claims information with MOM, and such data will be centralized and available to other insurers too. With this information, insurers are better placed to price the premiums based on their risk profile and claims history. Companies with fewer work injuries will enjoy lower premiums as compared to less safe ones. In this aspect, companies will be incentivized to ensure a safe work environment for their workers, which is likewise beneficial for them, as healthy and happy workers will be more productive and efficient at work. On the other hand, workers benefit when they return home safely. Lastly, the effect of amendments is expansion of compulsory insurance coverage to more non-manual employees, NMEs working in non-factories earning up to $2,600, an increase from the current $1,600, which will benefit another 25,000 workers, which comprise largely of junior professionals, managers and executives. As this group of junior PMEs are within the lower salary range, the compulsory additional coverage will provide greater assurance, both financially and emotionally, of coverage in the event of work injuries. As for companies, while at first it appears that there is an increased financial outlay in terms of insurance premiums, it must be borne in mind that should there be work injuries, the insurers will step in, which is a cost-saving measure in the long run. Where companies observe safety measures at work, there is a potential for lower insurance premiums. While the changes proposed under the bill are welcome, I would like to suggest some further enhancements to the proposed changes aimed at expediting the work injury compensation claim process and expanding the scope of mandatory insurance coverage. Under the bill, all work injuries resulting in any instance of light duty or medical leave would have to be reported by the employer. To speed up the claims process, work injury compensation claims will be processed for all work injuries reported by the employer. This will overcome the problem where the worker is not aware that he or she had to file the work injury compensation claim and is subsequently time-barred from doing so. Licensed insurers will process all claims arising from accredited work injury compensation policies to reduce the number of disputes arising from policies with complex exclusions. Last year, following a step-up of enforcement efforts by MOM, 39 employers were fined for failing to report work injuries, compared to only 1 employer in 2017. I note that under this bill, the penalty imposed on employers for failing to report work injuries has been increased. Auto-processing of work injury compensation claims would only serve the injured worker if employers comply with their work injury reporting obligations. I would therefore suggest the following measures to be taken to support the amendments proposed under the bill. First, MOM should audit employers to ensure that employers are complying with their obligations to report work injuries. This could be done with reference to third-party data, such as information from workers, unions, and medical practitioners. Accurate reporting of workplace injuries will provide a true representation of the extent of workplace accidents in Singapore and provide important information to licensed insurers to enable them to assess the premiums payable by the company. Apart from implementing audits on the employers to ensure compliance on their part, perhaps more could be done to educate workers and their respective union leaders of their employers' reporting obligations under the law, lest they be fearful of adverse repercussions. For instance, conducting seminars for the union leaders or workers or stating such avenues measures in the employee handbook which workers and employees can access on the employer's obligation to report work injuries. It is hoped that with more transparency accorded in the process, there will be a decline in failures to report work injuries. Second, injured workers should be kept in the loop in the work injury compensation claim process so that they are able to access the documentation trail and make informed decisions concerning the claim, such as whether to elect to take the claim to court instead. Injured workers should be notified when the employer reports the work injury and be kept abreast of developments in the work injury compensation claim process. If for some reason the worker elects to pursue his claim in court, it is likely that the employer may not be pleased with such a move for various reasons such as bad publicity, legal costs, etc. And perhaps it needs to be reiterated and emphasized that during the course of the litigation process, that the employer is not allowed to terminate the employee for reasons associated with the accident, save where permitted by law, failing which there might be legal consequences. Third, while the work injury compensation claim is being processed, the employers should ensure that the injured worker is able to seek the medical attention that he or she requires in an expedient manner with the employer's support. There have been reported incidences where injured workers were not able to seek medical treatment because the employer did not provide them with a letter of guarantee, and the workers had to go without treatment as they were unable to afford medical treatment. Fourth, there must be avenues for injured workers to raise issues encountered in the work injury compensation claim process to MOM. There have been past incidences where vulnerable workers have been coerced by employers to conceal work injuries in order to remain in employment. Some errant employers have also terminated employment arrangements of injured foreign workers and sent the workers home to escape liability. With the introduction of lower premiums for safer companies, some companies may be incentivized to under-report work injuries. As such, there must be avenues for workers or whistleblowers to report any malpractice for MOM's investigation. It is first commendable that there's a general increase in the compensation for work injuries under this bill to keep pace with wage growth and healthcare costs. However, we note that under the proposed amendments, employees will only be compensated the full average monthly earnings for the first 14 days of MC and/or light duty, and thereafter only 2/3 of the average monthly earnings of up to 1 year. It is odd that the workers are not able to be paid the full average monthly earnings for as long as they are on light duties, especially if the sole reason for being placed on light duty is because of their work injuries. Perhaps it is time to explore the possibility of paying workers the full average monthly earnings for the full period that they are placed on light duty and not limit it to the first 14 days. Granted that this could possibly mean increased cost on the employer's side or not being able to reap the full economic benefits from the employees and workers. However, it should be borne in mind that the decision and/or duration for light duties is ultimately the doctor's decision and based on a true and accurate assessment of the worker's sustained injuries and the doctor's assessment on how long the worker requires to fully recuperate before being fully fit to perform his original duties. In any case, any increased cost on the employer's part should be reimbursed by the work injury compensation insurance. The expansion of the mandatory insurance coverage to non-manual employees earning up to $2,600 a month, together with the lifting of compensation levels to keep pace with wage growth and rising medical costs, provide enhanced protection for vulnerable workers. In parallel with this enhancement, efforts must be set up to raise workers' awareness of their rights under the work injury compensation framework, and to also better monitor employers' compliance with the maintenance of mandatory coverage. Additionally, the government should also work with unions to continue encouraging companies who employ PMETs earning more than $2,600 to also buy insurance for peace of mind of employers and workers. Of course, this suggestion may raise resistance for employers. However, to alleviate such worries, it is proposed that the expansion of the mandatory insurance coverage protecting workers earning beyond $2,600 be imposed gradually in consultation with employers and in tandem with economic growth over the years. Second, it is important to bear in mind that the cost of insurance premiums would pale in comparison to the amount a company without insurance may have to pay an employee who suffers work injury under the common law. In any case, given that the risk profile of NMEs are significantly lower than manual employees, insurance premiums for NMEs would be lower. Employers can work with unions and the Migrant Workers Centre, NWC for short, for their foreign worker workforce, to raise workers' awareness of the rights under the work injury compensation framework. This will reduce the workers' anxiety in the event of work injury is sustained and smoothen the work injury claim process for all parties. Unions or NWC, as the case may be, can also assist workers with their queries on the work injury compensation claim process to enable them to make more informed choices concerning the work injury compensation claim. Workers can also seek free legal advice through legal clinics offered by the National Trades Union Congress and NWC in partnership with the Law Society of Singapore's Pro Bono Services Office. There have been instances where some errant employers have terminated insurance coverage for their foreign workers within the term of their work pass or had overlooked renewal of coverage. With the sharing of policy and claims data by licensed insurers with MOM and other licensed insurers, MOM can now implement a better monitoring system to ensure that employers maintain mandatory insurance coverage for foreign workers throughout the validity of their work passes. Audits should also be conducted on the insurance policies procured by the employer to ensure that adequate coverage has been secured for their workers and the type of work undertaken by the workers. Even with good processes in place, there must also be provision for cases which slip through the cracks. We must ensure that there are adequate safety nets in place to help injured workers to seek medical treatment and compensation in the event where the employer has failed to perform their obligations under WICA. With the increase in work injury compensation insurance premiums, it may be timely to explore if a small percentage of the premiums could be channeled to grow the Workers' Fund to provide relief in such exigencies. Sir, I stand in support of this bill and hope that my recommendations will be considered with the objective of enhancing work safety for our workers in Singapore for a more productive and efficient economy. Thank you.